Executors and Administrators Guide 92 entail. On the presentation of a petition stating the facts which show that the legacy is payable or an action may be commenced therefore in the Supreme Court, see page C Form Appendix 46. In case if any legatee is a minor, his legacy, if under the value of $50, may be paid to his father to use and for the benefit of such minor, and the legacy be of the value of $50 or more, the same may, under the direction of a surrogate, be paid to the general guardian, the minor, who shall be required to give security to a minor to be approved by the surrogate for the faithful application and accounting for such legacy. The security required in this section is in addition to the security given on appointment of the general guardian, obviously for the reason that a legacy given after the appointment made no part of the estate of the minor or which the amount of such former security was based. If there be no such guardians or the surrogate do not direct such payment, the legacy shall be invested in parliament securities under the direction of the surrogate, in the name of the benefit of such minor upon the annual interest, and in the interest may be applied under the direction of the surrogate to the support of the education of such minor. It shall be the duty of the surrogate where there is no guardian of such minor to keep in his office the securities so taken, and to collect, receive, apply the interest, and when necessary to collect the principal and reinvest the same, and also to reinvest any interest that may not be necessarily expended as aforesaid. On such minor coming of age, he shall be entitled to receive the securities so taken, and the interest of other money that may have been received in the surrogate, and his sureties shall be liable to account for the same. In case of death of such minor before coming of age, the said securities and money shall go to his executive administrator to be applied and distributed according to law. And the surrogate and his surety shall in like manner be liable to account to such executor or administrator. 9 2 RS 114 3 RS 5th edition 202. If after the expiration of 1 year from the granting of letters testimony to administration, there be more than sufficient asset to pay the debts of the testator or intestate, and if a reasonable demand made of the offer of a bond which sufficient sureties, as in the next section prescribed by any legatee or by any of the next in kin, to share in the distribution of the estate, such executive administrator shall refuse to pay the legacy banqueted by the will to such legatee, or the share of any such person entitled to distribution, he shall be liable to an action and the suit of such legatee or next in kin or their personal representatives. Previous of the commencement of the action, a bond of the executive administrator shall be filed with the clerk of court, the county clerk, with such sureties as the court or any judge thereof shall approve, in double the sum of such share of legacy, condition that if any debt owing by the testator or intestate shall afterwards be recovered or duly made to appear the payment of which there shall be no assets other than the said share of legacies, that then such person shall refund the legacy or share that may be recovered in such action, or such retireable portion thereof with the other legatee, representative of the deceased, as may be necessary for the payment of the said debts of the cost and charges required by a recovery against such executive administrator in any suit therefor. When given by the legatee, the bond shall be further conditioned that if no sufficient assets shall thereof remain to pay any other legacy which may be due, that then such person shall refund such retireable part or proportion thereof with the other legatees and representatives of the deceased, as may be necessary for the payment of the proportion part of such other legacies. A like action may be brought by the guardian of a minor entitled to the legacy or distributive share of filing a like bond and also a bond to the minor to account for the sum recovery of such legacy or share. And if it appear on the trial of such action that there are not sufficient assets to pay all the legacy, then the judgment may be taken for the proportionate part. The statute of limitation may be interposed in the surrogate or any other court in a proceeding to compel the payments of legacy. If it is shall appear that more than 6 years have elapsed since the same became payable, it is a bar to the proceeding. Smith versus Remington, 42 bar 75. But Kerr, 18 page 116. The surrogate having jurisdiction shall have power to decree the payment of debts, legacies, and distributive shares against the executive administrator of the deceased person in the following cases. Upon application of a creditor, the payments of any debt or proportion part thereof may be so decreed at any time after 6 months shall have elapsed from the granting of letters testamentary administration. Upon the application of legating and relative entitled to the distributive share, payment of such legacies and distributive share are in just proportion. 1 year shall have elapsed from the granting of such letters. The surrogate will act in these cases upon the presentation of petitions stating the facts which confer jurisdiction and will cite the executive administrator to show cause why payment should not be decreed. And if on the return date no cause is shown, an order will be made for payment, and such payment may be enforced by action upon the bond filed by the executive administrator. See Form Appendix. Payments of legacy or a distributive share or a part thereof may be obtained in certain cases against any executive administrator except the public administrator of the city of New York under the following section: 82 2 RS 98 3 RS 5th edition 185, and any person entitled to any legacy or to a distributive of share of a state of a deceased person at any time previous to the expiration of 1 year from the granting of letters testamentary of administration may apply to the surrogate either in person or by his guardian, after giving reasonable notice, receive such portion of such legacy of share as may be necessary for his support. If it has appeared to the surrogate that there is at least 1/3 more of assets in the hands of such executor or administrator than will be sufficient to pay all debts, legacies, and claims against the estate, then known, he may in his decretion allow such portion of the legacy or distributive share to be advanced as may be necessary for the support of the person entitled thereto upon the satisfactory bonds being executed for the return of such portion between interest whenever required. Ending at 97.